Hello, good afternoon, all. I am Kaushiki Roy, Assistant Professor at IIMT College of Law. Today, I will be delivering lecture on law relating to will in India. So now, I will discuss about the introduction part. The term will originates from the Latin word voluntas in Roman law, signifying a testator's intention. It's interesting that this abstract concept has evolved to represent the document containing the intention, much like other English legal terms such as obligation, bond, and contract, where the concrete meaning supersedes the abstract. The word testament is derived from testamentis, emphasizing its role in testifying to the determination of the mind. A will is considered a continuous act of gift until the donor's death. Although revocable during the donor's lifetime, it operates as a continuous act of gift until death, ultimately transferring the disposed property to the designated beneficiary. In the Indian Succession Act 1925, Section 2, Clause H defines a will as the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. According to the Judicial Dictionary, a will is the legal instrument whereby a man declares what is to be done with his property after his death. Will means the legal declaration of the intention of the testator with respect to his property which he desires to be carried into effect after his death. The word will shall extend to a testament and to a codicil and to an appointment by a will or by writing in the nature of a will in exercise of a power and also to a disposition by will. Bowier's Law Dictionary defines a will as the disposition of one's property to take effect after death. This term, expressing the final disposition of one's property, is specified to English laws and those jurisdictions influenced by them. Laws applicable to will. The Constitution of India 1950, according to entry 5 of the concurrent list in the Indian Constitution, the matters related to wills which were previously governed by personal laws in judicial proceedings before the Constitution's commencement are covered. The Indian Succession Act 1925, primarily dealing with the general law of testamentary succession, this act is applicable to wills made by Hindus, Buddhists, Sikhs, Jain, Parsis, and Christians, excluding Mohammedans. It consolidates existing laws without making amendments, and its provisions are to be treated with a similar effect as the replaced acts. Laws applicable to will. The Indian Evidence Act 1872, for a will to be valid, it must adhere to the formalities outlined in the Indian Succession Act 1925. The Evidence Act specifies that when a document is presented as evidence in court, at least one attesting witness should be called to confirm the document's execution. This applies only if one of the witnesses is available and subject to the court procedures. The Indian Registration Act 1908, registration of a will is optional under this act. It serves as evidence that the involved parties appeared before the registering officers who then attested the document after verifying their identity. However, the absence of registration does not imply anything about the will's authenticity. If a will is registered, it is securely held by the registrar. Muslim law on will. Muslim law, there is not a codified law governing wills among Muslims. Wills are made based on religious teachings, and it's important to note that there are differences between Shias and Sunnis in the Muslim law of wills. The Indian Succession Act 1925 does not impact the provisions of Muslim law concerning testamentary succession. Key sources for Muslim wills include Hidayah and Fatwa Alamgiri. According to Muslim law, any mentally sound and legally adult Muslim can make a valid will. However, the power of bequest is limited to one third of the net assets, and the two-thirds must follow the rules of intestacy unless all heirs unanimously agree to exceed the limit. The form of a Muslim will is not strictly required to be in writing, it can also be oral. No specific form of signature is mandated, and intention is the primary consideration. If there are no heirs, the entire property can be bequeathed with unanimous consent from all heirs. Christian law on will. Christian law, under the Indian Succession Act 1925, the process of making a will is uniform for all communities except Muslims. Like others, Christians can create a will when of sound mind and free from duress, coercion, or fraud. Mental capacity is essential, and while old age or disease may impair mental power, the testator must comprehend the nature and effect of the disposition at the time of execution. Formalities for a Christian will include being in writing, duly signed or marked by the testator, or signed by someone else under the testator's witness. Simultaneously, presence of both witnesses is not necessary. Christians also have the option to make privilege wills if the testator is employed as a soldier engaged in the actual warfare, expedition, or air service and is 18 years old. Privileged wills may be made orally in specific circumstances, but casual conversation does not constitute a testamentary act. Cogent evidence is necessary to prove the statements made by the deceased after executing the will to determine its contents. Judicial perspectives on wills. The Indian judiciary wills and some noteworthy cases are discussed below. In the Tagore versus Tagore case, the Privy Council emphasizes that a donor or testator cannot establish a new form of estate or line of inheritance solely to fulfill personal preferences. Principles guiding will construction also apply to the interpretation of a gift, since inheritance is also applied to the interpretation established by the state for public policy reasons. A private individual cannot create an unknown mode of inheritance. Hindu law principles apply, and if a testator grants property with an unconditional mode of inheritance, it fails unless valid as a gift. The net assets must adhere to the Hindu law rules, and testamentary power can only exceed one third with unanimous their consent. The Valaimai Achi versus Nagappa Chettiar case emphasized that if a person attempts to dispose of something in a will that they have no right to dispose of, the rightful owner can choose to confirm or dissent. In the case of joint family property, a father cannot change its nature through a will. The Hindu Disposition of Property Act later altered the rules related to unborn persons. is in wills. In Raman Nadar Viswanathan Nadar versus Snehapu Kasalama, the Supreme Court held that although there is no authority in Hindu law to justify the doctrine that a Hindu cannot make a gift or bequest for the benefit of an unborn person, yet that the doctrine has been engrafted on Hindu law by the decision of the Judicial Committee in Tagore's case, 1872. Though the decision is based on wrong reading of the relevant words of Dayabhaga, yet it has taken roots, maybe on the basis of the maxim communis error facit jus. In Gurudev Kaur versus Kaki, the Supreme Court pointed out that when execution of the will is fully proved, then, in order to ascertain the wishes of the testator, or we have to look to the text of the will. The intention of the testator has to be discerned from the language used in the will. If a will appears on the face of it to have been duly executed and attested in accordance with the requirements of the statute, a presumption of due exception and attestation applies. In Mathai Samuel versus Epin, the Supreme Court held that subsequent events or conduct of parties after the execution of the document shall not be taken into consideration in interpreting a document, especially when there is no ambiguity in the language of the document. Concept of living will. The issue of euthanasia has a long history stretching back to the ancient Greeks, Romans, and Indians. The right to a death with dignity was brought to the fore recently. Before this right was considered, the arguments surrounding euthanasia related more to morality, as with the Roman Stoics, and religion. For example, Judeo Christian philosophy considered suicide to be irreligious. Concept of living will. Living will is also known as advanced directives, advanced healthcare directives, advanced medical directives can all only be executed by an adult with a sound mind and who is physically and mentally in condition to communicate, relate, and comprehend the objectives and consequences of executing such advanced directives document. Living will shall be voluntarily executed and without an coercion or inducement or compulsion, and after obtaining the full knowledge or information about the conditions in which such advances directives can be executed, what treatment shall be given to the person and what not, who can give effect to those advantage directives. It is mandatory for a living will to be written format clearly mentioning as to when can medical treatment be withdrawn or a specific kind of medical treatment shall be given which will merely have the effect of procrastinating the death of the sufferer that may otherwise only prolong the pain, anguish, and suffering of that person. In Aruna Ramchandra Shanbhog versus Union of India, the Supreme Court allowed passive euthanasia, but before the case of Aruna Shanbhog versus Union of India, little was clear in India about the law applicable to testimony ill patients who wished to die a natural death by refusing modern medical life sustaining treatment. Common Cause, a retired society versus Union of India, the Supreme Court declared right to die with dignity was a fundamental right and that an advocate directive by a person in the form of living will could be approved. Advanced medical directive cannot operate as abstraction. There has to be safeguards. They need to be spelled out. We enumerate them as follows. First, The advance directive can be executed only by an adult who is of sound mind and healthy state of mind and in a position to communicate, relate, and comprehend the purpose and consequence of executing the documents. Second is it must be voluntarily executed and without any coercion or inducement or compulsion and after having full knowledge or information. Third is it should clearly indicate the decision relating to the circumstance in which withholding or withdrawal of medical treatment can be resorted to. Fourth is it should disclose that the executor has understood the consequence of executing such a document. Fifth is the document should be signed by an executor in the presence of two attending witnesses, preferably independent, and countersigned by the jurisdictional judicial magistrate first class so designated by the concerned district judge. Sixth one is in the event the executor becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and care of the ailment, the treating physician, when made aware about the advance directive, shall ascertain the genuineness and authenticity thereof from the jurisdictional judicial magistrate first class before acting upon the same. If the advocate advance directive is not cleared and ambiguous, the concerned medical boards shall not give effect to the same, and in that event, the guidelines meant for the patients without advance directive shall be made applicable. Conclusion. Wills are legally recognized documents which enables one's property to be distributed according to his or her desires or wishes. In case where a person dies without making a will is usually referred to as intestate situation, various issues may arise. So, writing of a will occurs various benefits, very little people do so. The most commonly type of will be embraced by individual are oral and written handwritten wills. In cases where there no will was written by the deceased person, the government law automatically controls and regulates property distribution among the beneficiaries. The improvement in current law relating to wills in India is required to make the present status framework more effective. Like a will should be made videographed. The person who is making will should medically examined. Thank you.